Welcome to another episode of Pinsky Law Presents. Today we're going to talk about the corporate existence of your fire company and important documents that you need to have, review, and file. Now, if your fire company's been in existence for 100 years or more, you really want to pay attention because you're going to be shocked at some of the things you learn. Now, the reference for today is going to be the Fire Department Law and Management Resource Manual, pages 200 to 204. And therein you can find a full description of everything you need to know as we talk about in this lecture. Now, first thing I want you to do, check your corporate name and your status. Well, of course we know our corporate name. I mean, it's been around for 100 years. And of course our status is still in existence. We're going to fire calls all the time. Or maybe we respond to ambulance calls all the time because we're an ambulance company. Well, New York State thinks differently. Here's the background. You see, up till 1957, the existence of a not-for-profit corporation was based on the law. And the law said every couple of years you are automatically dissolved and out of business unless you file a certificate or a document renewing your corporate existence. Well, that got tedious. So what did New York State do? Thankfully, New York State changes the law and says that a not-for-profit corporation will have perpetual existence. But before it did that, in 1957, it said, but guys, before we give you the right to last forever, perpetually exist, you've got to file a document with us and just tell us that you're still around. Well, we all know how good fire companies are for filing everything they need to file, and many fire companies never filed this. So what happened? In 1957, the New York State Department of State had a proclamation which dissolved any corporation which failed to file this. But I don't know whether back then, because surely I wasn't alive, I don't know whether back then the New York State, sent out any notice that said, by the way, you didn't file something with us, so you no longer exist. So what do we find today? We find so many fire departments, many of whom are our clients, that had never renewed and never chosen this perpetual status, and that they were actually dissolved by proclamation. In other words, as far as New York State's concerned, there's no corporation that exists. Wow, imagine that. The corporation was dissolved, and you don't know it. That means your members aren't protected by a corporation status, and it means that your members could be personally liable. This is huge, and we want to check that now. So we're going to go to the New York State Department of State website, and we're going to pull down under businesses. We're going to type in to the fields the name of your fire department, and we're going to see, is it still listed as active? Is the name correct? Well, it's important to have the correct name. For one, as you'll see, the law prohibits you from operating under any other name other than the one which the Department of State has on file with it. But more than that, your insurance company names a department. If it names some other department by some other name that's not your name, you may find yourself in a fight with your insurance company to actually be covered. Well, just quickly, what happens if you are operating under name 1, but you find that your actual name is name 2, but you really like your name 1 because it's on your building and all your trucks? Well, not a problem. We can get the Attorney General's approval to change the actual name. It's solvable. But don't let a lawsuit be the time that you discover that your insurance names a different company. So, we want to find a document called your Certificate of Incorporation. I know you think it's that big frame document that hangs over here on the wall and says, strangely enough, Certificate of Incorporation. That's not what we're looking for. We're looking for a document that, if it's old, is going to look like it's that old typesetting, possibly hard to read. And it might have been found on microfiche way back. And it's about 5 or 6 pages. It says on the top, Certificate of Incorporation. And this is a document that created the corporation. It will have on back the approval of the town or the village or maybe even the fire district that created the fire company in the first place. And it has some very important requirements. But let me tell you why we're talking about this now. The Certificate of Incorporation has requirements that are gospel to you. In other words, whatever the certificate says, you have to adhere to it. You can't change it in your bylaws, you can't change it in your policies, you can't overrule it in a resolution. In order to change your certificate, you sometimes need approval of the Attorney General, you sometimes need approval of the court, and you always need to file a change with the Department of State, which in and of itself is very difficult to do. So let's pull out your Certificate of Incorporation, and if you don't have a copy of it, I will tell you that for $15 you can order one from the Department of State. Now another small tangent. If you find that the Department of State has no record of your corporation or the corporation's existence, or maybe knows the corporation exists but doesn't seem to be able to quickly find its Certificate of Incorporation, let me give you a few suggestions. One, check with your county clerk. Back then, all certificates were filed also with the county, and even today, you will find that a copy goes to the county clerk, so you could find it there. And two, and you may need some help with this one, the Department of State does have old records, not digitized in any way, that will in fact appear if they do a manual hand search through the files, and they can find your actual Certificate of Incorporation from many, many years ago, most likely before 1957. Now by chance, they find that your corporation was dissolved. We can resurrect your corporation with the filing of a certificate. It's not complicated work for an attorney who does this to do, so your attorney may know how to do this. And it should never be very expensive to resurrect this corporation. But again, make sure you take care of that now and look now well before a lawsuit realizes you're not incorporated and you haven't been incorporated since 1957. So let's look at your certificate. You are going to see, and I'm betting that it's in paragraph 5, just because for some reason that's how it always was, that your Certificate of Incorporation provides for the number of directors. In other words, people on the board of directors. Now let me say, you may be like, we don't have any directors. We just have some chiefs and line officers and a bunch of members who run things. And although we have a president and a secretary and a treasurer, we don't have a board. Well, I got to tell you, Section 701 of the New York State Not-for-Profit Corporation Law requires that there be a board of directors with at least 3 individuals who are at least 18 years of age, and ideally they're going to be members, active members hopefully, of your corporation. You have to have this board. Section 701 says it is this board which actually manages the corporation. And in fact, this board, the individuals, can be personally liable for the waste or mismanagement of the funds and the monies of the corporation. So we need to make sure that we have a board. Now, if you have a board, or once we get a board into existence, as the law requires, let's make sure we have the proper number. There has to be at least 3. But many times we found, and this is especially true for some reason in village fire companies, that paragraph 5 of the Certificate of Incorporation states that there shall be 5 directors. Strange, it doesn't say there shall be at least 5 or there shall be about 5. It says there shall be 5. So if you've had fewer than 5 or more than 5, and that board has taken action, such as by signing a mortgage, signing a lease, signing any financing, signing any contract, or taking any action, you may find that that vote, that action of the board, because they had more or less than the required number of directors, was without authorization. Now, we don't use the term illegal too much, but it would have violated the law and thus been without authorization. So we need to look at that section. We need to amend that section. We need to get that section right out of your Certificate of Incorporation. And we do that through a document, what's called a Certificate of Amendment of the Certificate of Incorporation. Then we need to take a very important look at the purposes of the corporation. Now let me be really clear how important this is. The directors and the members of the corporation are provided an almost absolute immunity if they take action which in good faith they believe to be in furtherance of the purposes of the corporation. In other words, if you spend money, you buy something, you hold an event, you take almost any action that, again, in good faith you believe is furthering the reasons a corporation exists, as long as you did that with the belief that it was proper and did not otherwise know it was illegal, you cannot, should not lose a lawsuit against you or the corporation for taking that action. But here's the problem. Most certificates of incorporation have very few purposes. They mostly say to provide fire protection. But think about all the things we do. We recruit, we retain, we give money to little leagues, probably because it helps recruit, retain. We do fire prevention, fire education, we do a lot of things. But these aren't listed as purposes. So when you spend money or take action to further one of those other purposes, you may not have any immunity whatsoever because it's not listed in your certificate of incorporation. So what do we want to do? We want to amend your certificate. Now this will take, before I give you what we want to add, this will take the approval of the Attorney General and the approval of the municipality with whom you contract. So if you are located in a fire protection district, you have to get the town's approval. If you're located in a village, the village's approval. And if you're located in a district, you have to get the district's approval. So what should you have as purposes? Let me give you some examples. You should have to provide fire protection, of course, or ambulance services, rescue services, to provide first response or transporting a medical service, emergency medical services, if that's something you do. Definitely have to recruit and retain members, to educate the community in the importance of the fire service and in fire protection activities or in emergency medical services, to sponsor an auxiliary, to educate the community in first aid, maybe to support other community organizations such as we support Little Leagues. You need to list everything you do, and although we've provided you 6 or 7 examples here, our normal list of purposes that we draft for our clients is about 20 paragraphs in length. We want to cover everything you could possibly do and possibly spend money on or vote on or participate in to make sure you are given this qualified immunity from lawsuits. Now let me add, the Certificate of Incorporation for EMS agencies is going to have fewer purposes, but not too much different. But here, if the EMS agencies are going to bill for their services, make sure that your Certificate of Incorporation doesn't say we provide all our services without charge. Because if you do, you're going to violate this by billing. And you cannot violate your Certificate of Incorporation. You can only change it. You can't do anything else to violate it. You must change it. If you're going to have employees, make sure that you refer to allow yourself to have employees. What we see a lot of times is that EMS agencies say, we're going to provide this through our volunteers, meaning we're not going to have employees. We need to review the certificate and take that out. And if you list in the EMS agency's Certificate of Incorporation the area that you're going to serve, and you have since expanded that area through an expansion of your CON or expansion of your ambulance service certificate, let's make sure that we amend the Certificate of Incorporation to expand that area as well. We don't want to be acting outside the permission that we were given when the corporation was formed and placed into the Certificate of Incorporation. Now, what else do we want to refer to? Well, here's the thing. You know, when most of you were incorporated, when most of your entities came into existence, it was under a law that no longer exists. That law was called the Membership Corporation Law. And if you look at your Certificate of Incorporation, you will see references to the Membership Corporation Law. This law went away and later, in around the 60s, became the Not-for-Profit Corporation Law. And the Not-for-Profit Corporation Law has only been changed in substance, in significant substance, once. And that was a few years ago. But there were certain requirements that are now in the not-for-profit corporation law, which have to be in your certificate of incorporation, but were not before in your certificate of incorporation. Why? Because the membership corporation law didn't require it. So what are those things? Well, I've mentioned not-for-profit corporation law section 701. The first paragraph says that the directors shall manage the corporation. But that's not really how most fire departments and many ambulance services today manage their corporation. They have the members vote on all management issues. So we want to put in there, why? Because the law requires it, a paragraph that says some or all of the management aspects of the corporation can be performed by the members. If this is not in there, the members should not be voting on any management decision. And what's a management decision? I'm hard-pressed to find any decision that isn't a management decision. Anytime you're voting to do almost anything, and certainly to spend any money, this is a management decision. So is discipline, hiring, firing, contracting, supervising, controlling, lending, borrowing, all management decisions. Let's look at your certificate and get that power added so the members lawfully have the right to vote on management decisions. And we have to add the right to fundraise and solicit funds from members of the public. Why? Because the law says you have to have that permission listed in your certificate of incorporation. Otherwise, you're not allowed to fundraise and solicit donations. We want to check your insurance, as I mentioned before. Does the insurance name the correct corporation? I've covered this, but let's make sure it does. Does your corporation have directors and officers liability insurance? I sure hope so. Directors and officers can be sued personally for decisions they make or decisions they should have made. If there's a lawsuit against them and you do not have this directors and officers liability insurance, they may find that they have to pay for it on their own, out of their own pocket, to defend themselves against the corporation or against an angry member of the corporation. You don't want to be in this position. And I should also mention that in this case, your bylaws should have an indemnification clause. This is a little bit outside this lecture, but suffice it to say that your bylaws should have a lengthy clause which says, in the event any director or officer or member is sued by anyone for any action they took or didn't take, as long as it was in good faith, that they will be insured and defended by the fire company and thus its insurance company. Very important language, and this is complicated language that has to be drafted by a knowledgeable attorney. Now, if your municipality provides your insurance, let's make sure the corporation is actually protected and make sure that they purchase directors and officers liability insurance. For example, if you were in a village or a fire district, your insurance company may be protecting the village or the fire district, but may not have additional insurance, both naming the fire company and providing directors and officers liability coverage. I would go and ask your Board of Fire Commissioners or your village board, let's see if we can review your insurance policy. It's open under the Freedom of Information Act, so they should provide it. They have to provide it, but they should want to provide it. And if you need anyone such as an attorney to review it to see exactly what's covered, that's not a bad idea either. So let me just add this. What's good for the goose is good for the gander. So if your fire department purchases the insurance to protect the town, village, fire district, or city that you protect, you should make sure that you name the city, town, village, or fire district as an additional insured. Just as a note, each of those entities are liable for the negligence in providing fire protection and maybe other negligence as well of your members. So you need to make sure they're protected. Otherwise, that municipal organization will find itself without insurance. So again, I've told you this before, but let me reiterate it because it's so important. What is the actual corporate name? Check both the Department of State website and your certificate of incorporation, and let's make sure that you are operating under the exact name. And look, at worst, we can get you a doing business name, right? That's allowed, or we can change the name of the corporation to what you want it to be, but even though that's not what it legally is yet. Finally, let's talk about federal tax exempt status. I cannot underestimate the importance of saying, please don't ignore me. I know what you're going to say. Of course we're exempt. We have an exempt number. Of course we're exempt. We've been incorporated since 1902. Of course we're exempt. We take donations. Of course we're exempt. We have a sales tax exempt number. All of that means nothing. Trust me. Listen to me. This is important. It's going to cost you money and headaches if you don't listen here. We find that most fire companies and many ambulance services are not registered with the Internal Revenue Service as a 501c3 entity. Now let's be clear about a few things. You may have a number, but an IRS recognition of your tax exempt status does not result in the issuance of a number of any sort. What the IRS gives you is a letter. It's called a determination letter, that the IRS has determined that your organization is exempt from paying income tax. What if we're not exempt from paying income tax? Well, guess what? You got to pay income tax. And if you don't believe it, ask Al Capone. If you're not exempt, you're obligated to pay. And if you don't pay income tax, not only your corporation, but your directors and maybe your members may be responsible for paying the income tax. So listen up again. What's the number you have? Let's dispense with that. Well, if I have a number that's 2 digits, a dash, and a bunch of other numbers, like 16-99999, that is what's called an employer identification number. That's not proof of income tax status. Again, no number is. That simply means you're registered with the IRS as a corporation of some sort. Every corporation has an employer identification number. You also may have a TF number or a tax number, and that's a New York State income tax payment obligation number. Every corporation, if they don't get an EIN number by chance, will be issued by New York State a tax number. It's just a way to identify your corporation, and again, is not proof of anything other than your corporation is recognized to exist by New York State or the federal government. What about your sales tax exempt number? EX dash a bunch of numbers, but it always starts with EX. This is a state sales tax exempt number. It does not mean that you are exempt from income tax. It means that at some point, and likely before 1969, I'll explain that, you were given this sales tax exempt number so you could buy things without paying sales tax. But that doesn't mean you don't pay income tax. How do you have an EX dash number without being tax exempt? Well, today you can't get one. But federal income tax exempt status didn't exist until the late 60s, early 70s. So most of you got the sales tax exempt number well before that ever existed. New York State could today, if they audited you and they looked and found that you were not a 501c3 or actually a 501c, well, it's got to be a 501c3. I'm going to talk about that. If they found you were not a 501c3 entity, they could take your sales tax exempt status away. Another reason. Now, you're going to say, yeah, but we're a 501c4. Aren't we exempt from income tax? Yeah, you are. But a C4 is like the silver standard. A C3 is the gold standard. What's the difference? Well, with a C4, you're not supposed to have sales tax exempt status. With the C3, you can get it. With the C4, the U.S. Postal Service is not supposed to and will not give you their special postal rates for charitable organizations. And in the C4, some of your donations are prohibited, such as if somebody leaves a will, a large bequest to you, may be prohibited from you receiving. And the amount of donations that any one person can give may be prohibited or limited, more likely limited. You want C3 status. Why? Because it's the gold standard. It entitles you to everything I said. Why do you have C4 status and not 3C status? Well, you have that because years ago, the IRS, about 15 to 20 years ago, the IRS wouldn't give C3 status to a fire company. They would only give C4 status. But many years ago, some firms like ours petitioned the IRS and received many approvals for the fire department, challenging that rule. And so for more than 2 decades, I've been obtaining C4 status for fire departments. And yes, way back, this wasn't common. And your accountants today may say, yeah, you don't need it. Trust me, you do. There are grants that are not available to C4 entities, only C3. The state legislature, when it gives money through these member funds or DACA funds, need to give them to C3 entities, not a C4. So get your C3 status. If you just don't want to listen and you say, listen, we haven't done it for 20, 30, 40 years, no problem. Well, guess what? You're not only going to lose all these benefits, you're going to put your donors in great jeopardy because they believe that donating to you is tax deductible. And if they're deducting donations made to you and you're not a C4 or at least, right, a C4 at least or a C3, your taxpayers are going to get pretty upset with you. And you're not going to see donations. And you're going to see a news article that probably alleges you misled your taxpayers and donors. And God forbid you're soliciting funds from them in an annual fund drive and you're not a C4 or a C3. You need to be one or the other, but please get your C3. And you can convert from C4 to C3 status. We can help you if you need it, or an accountant can do it for you. But you should convert to C3 status. It's a one-time thing. Unless if you do not file the annually required Form 990, and there are 3 versions of it. It depends which amount of income you receive, and then that dictates which form you file, whether it's a full 990, a 990 EZ, or just a postcard 990N. If you have one of these forms filed, and all of a sudden you stop filing for 3 years in a row. So in other words, you got your C3, C4 status, and for 3 years in a row you don't file. You will automatically lose your exempt status. You will lose your C3 status, your C4 status, whatever you got. If you don't file your 990 in some form, full EZ or 990N, you will lose your exempt status. And the fines will start rolling in. And we have seen fines in the tens of thousands of dollars. Now, for a first-time offense, those fines are usually waivable, so don't panic. But if you keep doing it, it's going to become very expensive for you. So what's our kind of ending pitch to you? Check your certificate of incorporation. If it hasn't been updated in 30, 40, or 50 years, we should probably give it a once-over, and we should probably update it. Make sure that you're filing a Form 990 in some form, because if you're not, even if you were at some time, you're no longer exempt under the IRS's rules. And if you're a C4, strongly consider converting to a C3. If you will do all of these things, your corporation will have a very strong foundation upon which you can build bylaws, policies, rules, and regulations without the fear that you could be personally liable or taking actions which you shouldn't be taking. Well, that's it for this episode of Pinsky Law Presents. I hope you got something valuable out of this, and we'll see you next time.